Some of the
Is it
claims.
clear on manifest error or just manifest error?
Okay, it's clear error. Sorry, there's manifest injustice and clear error. I'm mixing it
All
up.
right.
I apologize.
All right, now I'll call the number case. Appearances, please.
Good morning, Your Honor. Todd Prall on behalf of the third party plaintiffs. David Mahon is with me in the courtroom, and Mr. Bragg is also on Zoom.
Good morning.
Good morning, Your Honor. Rory Kay of McDonald Toronto on behalf of Spin Games, Kent Young, and Kunal Mishra.
Good morning, Your Honor. Danielle Barraza on behalf of Brian Marcus.
Good morning, Your Honor. Steven Caloiaro on behalf of Bragg and Onyx.
Good morning. All
Your
right,
Honor, Richard Newman on behalf of Law, Richard Newman and Cooper Blackstone.
third party plaintiff's motion to alter or amend judgment dismissing the action pursuant to NRCP 59E.
Good morning, Your Honor. Todd Prall on behalf of third party plaintiffs. I believe our motion and a reply outline the arguments that are issued here. I'm just going to highlight a few things here. First of all, we wouldn't really be here if the court was clear on what its order meant when it filed it when it signed it in July. I just want to, again, we believe that the biggest issue here is that there is manifest error if the court has determined that some of the
Is it
claims.
clear on manifest error or just manifest error?
Okay, it's clear error. Sorry, there's manifest injustice and clear error. I'm mixing it
All
up.
right.
I apologize. Manifest injustice is what we think is here, and clear error. If the court now believes that its order dismissing this case did not dismiss the claims against Marcus or the Newman,
Which is a matter that I previously took under advisement, and I'm still holding that in advance.
and you haven't made a decision, but clearly the fact that you didn't just say, no, we're done, it means, to me, there could be clear error here, and that's why that's the primary reason we brought this motion, is that either the case is dismissed under the 5-year rule as to all the claims because it has expired, or if it has not expired as to some of these defendants, it really can't have expired as to any of them, and none of them should be dismissed.
A single action, right?
It's a single
We're
action.
not talking about consolidated actions here. We're talking about a single action.
Right, these weren't consolidated.
Right.
This is all one action. Third party plaintiffs sued all these people, one action, complaint, counterclaim, third party claims, all of them were brought together. And as you know, your court order says, and it's on page 19 at the very end, it is further ordered that all claims, causes of action, and defenses in this action are dismissed under NRCP 41E because the original complaint was filed on August 11th, 2017, and none of the parties brought this matter to trial by April 27th, 2024. That's your court order.
So
That's what it says.
what's unclear about that?
Well, you tell me, because you're the one who didn't just declare the motion for summary judgment that Marcus brought as moot. You for some reason you don't think it's clear, and so I don't know if that's we think that if there's any reason that the court believes the other claims are still alive and that they were not dismissed, and that there's a different 5-year rule that is calculated to the claims against Newman and Marcus, then that's clear error for the court to have dismissed some of the claims without dismissing all of them. That's our first argument. Now, we do argue, Your Honor, that we believe that all of the claims should not have been dismissed, and that under Rule
Based
40,
on your time calculation.
based on the time calculation presented in our motion, I don't know if we need to add more to that. I think that argument is pretty clear. What our argument is that the stays that apply to the Newman parties and the Marcus parties should apply to all of the should make it so that there's more than one calculation for the 5-year rule, and since they're all in one action, the longer one applies. That's our argument, and we believe that to the extent the court believes that, again, that those actions, that somehow there's a different calculation that applies to Newman and to Marcus, that means that none of the case should be dismissed under 41E5, where it pretty clearly states that the longest, if there's more than one period that applies to an action, the longest one is the one that you use. And we've stated our arguments pretty clearly. Again, it is based on the stay of discovery. Those arguments have been made multiple times before this court. And we know their position, you know our position on it, that we don't think that you can legitimately bring a case to trial when all of discovery is stayed. And even if it's not staying the whole case, it keeps you from going to trial. And that's been our argument. And we, again, now we see that it gives us more time than we thought with the Newman and the Marcus parties, and it applies to the entire case. So that's the argument there. The real issue here, Your Honor, and the reason we need clarity is your court's order does say, and again, we think it's pretty clear that it was dismissed, but your court order in paragraph 90 through 93 says, first of all, it says that dismissal under NRCP 41E1 does not depend on the nature of the pleading, complaint, counterclaim, third-party claim, and deadline applies to all parties in an action. That's based on the Journeyman or the Manson case that you cite. Because of this, the court must dismiss all causes of action in the full color parties consolidated third-party complaint filed on November 22nd, 2021. Then paragraph 2091 just notes that the spin party's counterclaim was defensive in nature. It's like a fourth party claim, counterclaim, and it should also be dismissed. And then the confusing one is paragraph 92, where it says for avoidance of doubt, this order resolves all claims brought by or against the Bragg and spin parties. Because the court finds that there's no just reason for delay, the order shall be a judgment under NRCP 54 as to the Bragg and spin parties. Usually when you use the term for avoidance of the doubt, you don't narrow your prior order. You just clarify it as to one thing. But what they're trying to argue is somehow that narrows what you already held. That it's all dismissed. That's not what it does, in our opinion. It's either all dismissed or not. So we have argued that it's error because the other two parties, if we calculate based on the calculations we've provided, the time is not expired and you need to go with the longest time. And our biggest concern is that it either should be one or the other. You should either keep the whole case here or it should all be dismissed. It can't be split up. The minute you think it should be split up tells us that that you're applying the wrong calculation. So that's the biggest point. And the opposition attempts to argue that you can do that in Nevada. And they say, well, Nevada court hasn't really ruled on that before. And now we're going to look at the California courts to see what they say. That's wrong for two reasons. Number one, they ignore the cases that are cited in your order that they cited in support of their motion to dismiss, that you can't calculate different parties or defendants differently. You look at it as a whole as one action. They cited that. That's what their motion to dismiss is based on. And then here they're like, well, we're not going to even talk about that. We're going to say that the court hasn't addressed this issue. We're going to look at California law. California law actually supports our position. The case should not be dismissed. So if they want to look at California law basically says that the time that should be used to calculate when the 5-year rule commences is based on when the pleading that brings a defendant into the case, not based on the very initial complaint. Each defendant is calculated separately, which is what they're now arguing allows you to split up the case. So we believe that if that argument is taken, that is clear error. And again, the biggest point here is you need to do one or the other. Everything's dismissed or everything stays. We think it should stay. That's our argument that we make under 41E5. The longest time period is not expired, and it should not be dismissed. The only other thing that I wanted to briefly address, Your Honor, is that the Marcus parties are the ones who argue hardest that they should be able to just have their motion heard on summary judgment and not have it dismissed. And they've spent some time arguing about why they're entitled to fees under NRS 1805. Now, it's important to note here, Your Honor, that NRS 1805 is not limited in the way it can remedies. We would oppose any motion they brought for fees, but there's nothing that says they can't bring it, even if it's dismissed either way. There's nothing that says that that's not a proper motion, at least for them to bring. So either way, if the court's inclined to do that at all, though, we would request that it just be rebriefed so that we can brief that completely. But we don't think that's appropriate. We think the case should just be dismissed and we should move on. But they do argue that you should just grant their fees even if you dismiss. And I don't think that should be done without it being briefed separately. That is our position. But again, Your Honor, unless you have other questions for me, I think our briefing basically points out our position. And I don't have anything further to say.
All right, thank you.
Thank you, Your Honor. Rory Kay for the spin defendants, as the party opposing. And I heard a lot of new things in there. What I didn't hear was any new evidence. I didn't hear about a change in controlling law. In fact, I heard citations to cases we've been arguing about for over a year. And that's the first issue with this motion, is procedurally they don't meet the threshold for reconsideration or amendment. Now they say, you know, they cite manifest injustice or clear error, but this is the proverbial second bite at the apple. In fact, it may even be worse, because at least with respect to the anti-SLAPP argument, they're now raising an argument that they never raised before in any of the briefing before you. And I went back, Your Honor well knows, we've been briefing the 5-year rule before you since June of 2023. The first motion that full color parties was filed on that date. It was a motion to quote clarify the 5-year rule. Nowhere in that motion did they make this anti-SLAPP argument that they're now making. They also filed, as you probably recall, motions to bifurcate for a preferential trial setting in July of 2023. I went back and reviewed those to make sure I hadn't missed anything. In that motion, they didn't argue any different calculation as to the anti-SLAPP motions filed by Mr. Newman and Mr. Marcus. And so, of course, we also have the writ petition that went up in November of 2023. Mr. Reynolds at Hutchinson Steffen represented full color in that. I think he's probably one of the best appellate attorneys in the state. I went to look at Mr. Reynolds' brief, no mention whatsoever of the anti-SLAPP argument, otherwise altering the calculation. And then finally, I went to their opposition to the spin and Bragg party's motions to dismiss. Surely they would have put the anti-SLAPP argument in there if it was manifest injustice or clear error, as they now claim. Again, no argument whatsoever about the anti-SLAPP calculation somehow tolling or calculating or extending, if you will, the 5-year deadline. And so the idea that they get reconsideration or amendment here on the anti-SLAPP argument simply isn't procedurally appropriate. It's also not substantively correct. We've already gone through the Boren exception in anti-SLAPP motion, and the anti-SLAPP appeal doesn't in and of itself stay the entire case or otherwise qualify under the Boren exception to the 5-year rule. And we know that's particularly true in this case for at least 3 reasons. One, you never entered an order after the anti-SLAPP motion staying the entirety of the case. You didn't even enter an order staying discovery as to Mr. Marcus and Mr. Newman. You didn't have to, because there was no discovery ever served on those 2 third-party defendants by the full color parties during the entirety of this case. So that's the first issue. There was no order on the anti-SLAPP motions or appeals staying the case. The other issue is, and this is correct, Mr. Newman filed substantive motions while the anti-SLAPP appeal was ongoing. The case wasn't stayed even as to Mr. Newman during that time. The full color parties themselves filed various motions, amended pleadings, all those wonderful things that changed or altered the substantive claims and allegations against both Mr. Newman and Mr. Marcus. So that anti-SLAPP appeal didn't stay that. And again, even had you entered an order, which they don't identify anywhere related to the anti-SLAPP motion or appeal, it only would have stayed discovery as to those 2 defendants. Certainly wouldn't have stayed the entire case, wouldn't have stayed the case as to my clients, the spin parties, wouldn't have stayed the case as to Mr. Caloiaro's clients, the Bragg parties. And so there's no tolling effect under the 5-year rule. The math is the math as to all third-party defendants. That math is in paragraph 89 of your order. The 5-year rule in this case expired on April 27th, 2024. And so this brings us to sort of the final issue, which is their argument that somehow your order is unclear because it carves out Mr. Newman and Marcus. There's 3 reasons, Your Honor, why we did that. One, you may recall we had to ask for several extensions in the 14-day deadline to submit an order. The full color parties were trying to decide to do what to do with Newman and Marcus. We as the full color, or as the spin parties, Mr. Caloiaro as the Bragg parties, we needed an order entered, particularly because with respect to our clients, you know, we have the second action. We can't just wait for full color to figure out what they're going to do with Mr. Newman, Mr. Marcus. The other point is that Mr. Newman and Mr. Marcus weren't movements. on the motion to dismiss that precipitated this order. Only the spin parties and the Bragg parties moved. Mr. Newman, Mr. Marcus didn't join in that. In fact, they hadn't filed anything in this case since March of 2022 for Mr. Newman, January of 2022 for Mr. Marcus. And Rule 41 isn't self-executing. A defendant that wants to avail itself of the benefit of Rule 41 has to move for relief. That's provided by NRCP 41C. The other option is if nobody does anything, Your Honor can issue an order to show cause. So it would not have been appropriate for me as counsel for the spin parties or Mr. Caloiaro as counsel for the Bragg parties to submit an order that dispose of the claims of Mr. Marcus or Mr. Newman. Obviously, Mr. Newman represented himself because Marcus has able counsel. If they want to avail themselves of the benefit of Rule 41 or anything else, they have the power to do so. The final point and the final reason why we didn't include Mr. Newman and Mr. Marcus specifically in the order is that the claims are completely distinct from those against my clients. And I'll take you back to that amended and restated motion to bifurcate that the full color parties filed way back in July 31st of 2023. And they say the claims against Newman and Marcus, I quote, are very different from the claims against the spin parties and the Bragg parties. So me, as counsel for the spin parties, Mr. Caloiaro was counsel for the Bragg parties, didn't think it was appropriate for us to be submitting an order disposing of claims that are, quote, very different from the claims against our client. But we do agree that the 5-year rule is the 5-year rule. Mr. Newman wants to invoke that protection, and I think he has in his opposition. He's entitled to. It's one 5-year deadline for all third-party defendants, and that deadline ran back in April of 2024. So with that, I guess I would say Your Honor can deny the motion, but if there is any sort of ambiguity in who is dismissed, Mr. Newman has now joined in the calculation of the deadline that's in your original order. If you want to amend your dismissal order to add Mr. Newman, I think that's appropriate as a matter of judicial efficiency. As to Mr. Marcus, he would also be entitled to dismissal.
So my understanding is you generally agree with the concept that it's an all or nothing situation?
Yeah, I think as a general concept, that's correct, and even more important in this particular case, it's the same deadline as to all third-party defendants. The math is to everyone. There was no tolling order whatsoever in this case as to any of the third-party defendants. So we do think now that Mr. Newman has affirmatively invoked that, he's entitled to be rolled into the dismissal order. You know, Mr. Marcus has his pending motion. He's represented by counsel. I can't speak for counsel as to where Mr. Marcus wants to go, but what I can tell you is our view as the spin parties and the Bragg parties, Mr. Marcus would also be entitled to dismissal under Rule 41 because there is only one deadline. It's the deadline that shows up in paragraph 89 of your order. So with that, unless Your Honor has any additional questions, I will rest. I know Mr. Caloiaro from the Bragg party may have something to add if I've missed anything, Your Honor.
Good morning, Your Honor. I'll be quick. I know we're really late in your calendar today. Mr. Kay did a wonderful job kind of discussing all the issues that we feel are evident in the motion and the reply. But I would be remiss if I didn't touch on the procedural defects that Mr. Kay touched on. You know, at no point in any of the proceedings before you has the third-party plaintiffs raised this issue. And it wasn't till after the judgment was entered that they all of a sudden came up with this new theory as to why they're entitled to an amendment of the judgment. That is not the purpose of Rule 59E, Your Honor. They haven't identified any new evidence or any change in controlling law. All of these things could have been raised well before the underlying actions they say give rise to their motion occurred in 2021. So I'm at a little bit of a miss as to why we're here today, Your Honor. It seems that this is nothing more than the third-party plaintiffs trying desperately to maintain this action, which we've told you for the past 3 years, lacks any basis in law or fact. And once again, this motion again appears to lack a reasonable basis and shouldn't have been brought.
All right, thank you.
Does Mr. Newman or Mr. Marcus want to argue for, or do I just?
If I could do a brief argument for Mr. Marcus's opposition.
Sure.
I just want to give a little bit of background briefly. The reason that Mr. Marcus moved forward with his motion for summary judgment was because in the court's minute order on the spin and Bragg party's motion to dismiss, that minute order specifically stated, in effect, motion to dismiss is, granted, and the parties need to circulate the draft order to all parties involved. So presumably, if that order dismissing only the spin and Bragg parties applied also to Mr. Marcus, it would have been circulated to his counsel. We never got that order. We also saw the language from paragraph 92 of the court's order, which says this order resolves all claims brought by or against the Bragg and spin parties. So that's why we move forward with our motion for summary judgment, because of the language of the court's order and our understanding that if we were in any way involved, as far as Mr. Marcus involved in the court's order dismissing the spin and Bragg parties, we would have been given the draft order. That was never done. And so we do think ultimately that, had Mr. Marcus elected to join into the spin and Bragg motion to dismiss based on the 5-year rule, that the calculation would have been the same. He didn't elect to do that. He elected to move forward with his motion for summary judgment. And just to briefly address the argument about the fees and costs, that's already been briefed. That's been briefed in Mr. Marcus's motion for summary judgment. For some reason, they elected, not to really dispute most of that section on fees and costs. I don't know why, but we absolutely do not think they need any second bite at the apple as far as additional briefing on the fees and costs that Mr. Marcus should be awarded, whether it's under a 5-year rule dismissal or a motion for summary judgment dismissal.
All right, thank you.
Mr.
Anybody
Newman,
else?
want to add anything? Is Mr. Newman here? I don't know if he wants to add anything, he may not.
Okay, go ahead, Mr. Prall.
Your Honor, I want to be clear about a few things. They have just to be clear, their arguments about 59E narrow 59E way more than it should be. We are here to be able to argue if there was clear error in what the court did. And everything that is said is made it clear that the way the court initially issued its order, first of all, 41E, there's case law that clearly says you don't have to be a movement to get dismissed. So this argument that, they didn't move doesn't mean they shouldn't be dismissed. I will say this, the whole reason that this happened this way is you're right. The other two parties really didn't participate, so all of the briefing was focused on spin and Bragg and how that worked. That's totally true, but that doesn't mean at this point we shouldn't. We feel obligated to make sure the court gets this stuff right. That it's not. You need to either you got to follow the law the way it is or not. And this just created a lot of confusion for us, and that's why we did that. We never even reached an agreement on the order that was submitted because of the way that when the court issued its minute order from us, we were trying to figure out how that affected the other parties, and we weren't sure. And then when we look at it, we're like, well, no, everything points to that way. And then when they filed their motion, suddenly Spin decided to not include them. And anyway, the point is that is why we're here. It's a legitimate reason for a 59E motion to get this cleared up, to make it right. And it was also legitimate for us to bring up issues that apply to the Marcus and the Newman parties, especially when Marcus himself came in his opposition to our motion for summary judgment with the theory that it had not expired. And so we're like, well, he argued that too. And if that's the case, if the judge thinks that's true, then 41E5 requires you to look at the longest period for the entire action. And so this was a legitimate motion that needed to be brought to correct and figure this out, especially since we know it's going to go on an appeal. It needs to be done right. And that's why we're here. It's not a waste of court's time to do this. And for them to argue that is just silly. The other thing I would like to note, Your Honor, is that they brought up this issue with, these claims are completely separate, and that's why we didn't do it, because we did make a motion to bifurcate. They're right. But they argued that it shouldn't be bifurcated. And they argued vehemently that it shouldn't be. And they said it's all together, that you can't separate these apart. And you agreed with them and denied the motion to bifurcate. So they are all together and they should be treated all together. This isn't a case like the California case they cite, Brunzel, where there was still an issue of whether or not these two different groups of defendants could be severed and tried separately. You already issued an order denying that. They opposed it. They didn't think it should be tried separately. And now they're trying to say, well, now we just viewed it as two separate claims, even when they were clear, always arguing that it should not be two separate distinct claims. So for them to bring that up now is just disingenuous. But anyway, that's unless you have other, and on the last thing on NRS 1805, we think it needs to be rebriefed just to make it clear that it's under standard for the dismissal that is appropriate. It should not be based on the motion for summary judgment that frankly is moot, and the court really can't entertain it if the entire case is dismissed. Which either it should be or it should not be. So with that, Your Honor, unless you have other questions, I don't have anything.
No, I don't. Thank you very much. It's been very well briefed and argued. I need to review it further, and it's under advisement and restore the other matter to the, that's the what's his name? The Marcus case. That's restored to the under advisement list as well.
Okay, and you know, just one other point. We believe that the order as it's written applies to all the parties. I don't think he says we should add them in. I don't know if you really need to do that, but if it makes it clear for appeal, we should do that.
No, but what I had taken under advisement, the motion for summary judgment.
Correct.
Mr. Marcus, correct? And I then issued an interim order indicating that I thought that what's coming before me today would assist me in making my determination on that motion as well. So what I've heard today is under advisement, and the other matter is restored to the UA list as well. I'll issue my rulings on as soon as I can. Thank you very much.
Thank you very much, Your Honor.
Thank you, Your Honor.
Brief break and